Good evening to all of you. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. I would like to extend a warm welcome to all of you to this Global Legal Education Colloquium on the theme Higher Education and Research in Law, preparing the next generation of legal thinkers, lawyers, academics, and judges. I have a very distinguished group of guests and panelists who are here who have lived an extraordinary life with so many different experiences. Before I formally introduce them, let me introduce the theme of this evening's colloquium. While legal education educates the youth to become professional lawyers who fulfill the demands of the legal profession, it is also instrumental in nurturing the change makers of tomorrow who can address the legal, social, economic, and political challenges that have plagued the world. Law is believed to be an instrument of social change and social engineering in a number of societies. History has shown that some of the greatest leaders across generations have been lawyers. While traditionally lawyers perform key roles and responsibilities in the legal systems of different nations as litigants, advocates, judges, justices, today there is a demand for legal experts across all aspects of the profession, including but not limited to corporate organizations, NGOs, think tanks, research institutions, and legal academia. From private law firms to corporate general legal counsels, lawyers are omnipresent. They not only play their primary role of dispute resolution, but are also instrumental in structuring the governance and policies of nations, as well as establishing a society based on the rule of law, including contributing towards access to justice. This is probably a momentous time in history to witness the importance of legal interventions, as the current health crisis in the form of COVID-19 has visibly spiraled into a humanitarian and economic tragedy, with law and legal institutions demonstrating at times their own helplessness. The pandemic has once again highlighted the significance of law in not only fulfilling the demands of justice, but also resolving the socio-economic challenges faced by countries. Therefore, today, it is all the more important to create robust higher education and research initiatives in the field of law and reimagine the future of higher education in law, from identifying initiatives to improve quality of teaching to developing more attractive career trajectories for students in the areas of judiciary and academics. Law schools must find their ways to reinvent teaching and learning methodologies. At the same time, the transition to online learning to ensure academic continuity in times of this pandemic has allowed us to break the inertia of integrating technology with law and legal academics. Robotics, artificial intelligence, and machine learning are potentially going to change the very fundamentals of legal profession. We must leverage this opportunity to drive innovation in research and legal technology and create possibly more technology immersion experiences at law schools, being fully conscious of the limitations of technology and indeed the challenges technology poses towards both civil liberties as well as our effort to protect the right to privacy. All these issues are part of our discussion. Therefore, this colloquium is an important platform to discuss the role of higher education and research in law in preparing the next generation of legal thinkers, lawyers, academics, and judges. I have great pleasure in welcoming my distinguished group of panelists. Mr. Adam Kolker is the Assistant Dean and Executive Director of International and Comparative Law Programs at Columbia Law School. He has held similar positions at Georgetown University Law Center and the University of Pennsylvania Law School, where he taught international civil society law with ICNL's president. He has served as a member of the Academic Council of the Ibero-American Caribbean Law and Public Policy Institute of the China University of Political Science and Law, as well as the Dean's Advisory Board of the Qatar University College of Law. He was part of a team that worked with law schools in 20 countries on 5 continents to create the award-winning Center for Transnational Legal Studies in London. Thank you very much, Adam, for joining us this evening here in India and morning in New York. We have with us my very dear friend, Mr. Vikram Raghavan, who is the lead counsel at the World Bank. He's the bank's legal advisor for conflict, refugees, and macroeconomics. Over his 19-year bank career, which is apparently today, when he is completing 19 years, Vikram has worked for projects in many countries. Drawing on his experience, Vikram was involved with the landmark World Development Report on Conflict, Security, and Development. He received the Bretton Woods at 75 award for his outstanding contribution to preserving the bank's institutional memory. Before the bank, Vikram was an associate at a law firm called O. Melvin and Myers in New York City, where he did banking and international arbitration. Vikram studied at the National Law School of India, University, Bengaluru. He obtained his master's in international law from the NYU Law School. He belongs to a generation of lawyers in which he provided distinguished leadership in inspiring them and also helping them achieve their own aspirations. Thank you very much, Vikram, for joining us this evening. We have with us Ms. Jane Chukowski, who's the former Executive Director of United States Educational Foundation of India. Jane earned her BA at Boston University, JD at Vanderbilt University, and an LLM at Georgetown University, a tenured professor at the University of Baltimore School of Law, Maryland. She established clinics, taught contracts and law and social reform. She was a Fulbright scholar at the University of Colombo, Sri Lanka, and directed an LLM program for the foreign lawyers. Jane worked in India for 14 years. She was executive director of the US-India Education Foundation, member of the governing body of OP Jindal Global University, and was also the CEO of SM Segal Foundation, an NGO working in the rural development sector. Thank you, Jane, for joining us this evening. We have with us Dr. Agya Sengupta, who's the founder and research director of the Vidhi Center for Legal Policy. His areas of specialization are constitutional law and regulation of the digital economy. He has served on a number of government committees, including the BN Sri Krishna-led Committee of Experts on a Data Protection Framework for India. Agya has a number of academic publications on the Supreme Court and the Constitution in leading law journals such as Law Quarterly Review and Public Law. He has most recently authored a book entitled Independence and Accountability of the Indian Higher Judiciary, published by the Cambridge University Press in 2019, which builds on his doctoral work at Oxford University. Prior to founding Vidhi, he was at Oxford as a lecturer in administrative law at the Pembroke College, Oxford. Thank you, Agya, for joining us this evening. We have with us Dr. Suraj Singh, a senior advocate at the Supreme Court of India. Dr. Singh has 3 master's degrees in law from the University of Delhi, from University of Oxford, and from Harvard Law School, where he also obtained his Doctor of Laws. He was the contemporary of President Barack Obama at Harvard Law School during the years 1988-90 and attended his both presidential inaugurals in 2009 and 2013. Over the last 3 decades, Dr. Suraj Singh has argued over 2,500 cases involving complex questions of law and justice. He has advised several chief ministers and cabinet ministers and numerous members of parliament on important points of law. He has represented leading multinational and Indian corporations and won against many important corporations as well. He has taught advanced course on Supreme Court lawyering with Supreme Court judges and leading lawyers of India. Thank you, Dr. Suraj Singh, for joining us this evening. My first question this evening is actually to Dr. Agya Sengupta. Agya, now we are of course in a very unique situation when it comes to legal education, higher education, but keeping the COVID-19 crisis for a moment away from our discussion, what do you think is the role of higher education in law to create social, economic, and political reforms? What are your views on the current state of legal education around the world, particularly in developing countries like India? In countries such as India with a high student population, how do we balance between the quality and access of legal education for aspiring lawyers to strengthen the laws of the nation while ensuring equal access to justice? We know that we have 1,650 law schools in India. We also know that we graduate approximately 75,000 law students every year. And we also know that we have over 1.5 million lawyers who are expected to be around. We of course don't know very reliable statistics there. Agya.
Thanks, Raj. I think there's a couple of questions in there, and I'll take them one by one. One about legal education in India and where it stands, and the second about law and social change. So I'll try to be as brief as possible. So taking the second question first, I'm reminded actually of what Lord Bingham had said, that a lawyer without a knowledge of history is like a mechanic, and perhaps a very poor one at that. And I think that as law students and lawyers, we need to understand that our role is necessarily a public one. While the daily rigmarole of the law is essentially private, it could be between 2 parties, but it has ramifications on the way in which society functions, which is why lawyers have typically been prominent in public life in most countries, and most certainly in India. If you look at the founders of the Constitution, not just the ones we know of, like Ambedkar, but everyone on the drafting committee of the Constitution, bar one, was a lawyer. And the reason for that is that it's expected of lawyers, there is a societal expectation of lawyers that lawyers will, it's a noble profession. We have to think of the public good. And so I think there is a deep connection between lawyers and the and societal expectations that lawyers will be at the forefront of social reform as individuals who are public minded. Now, having said that, and that's the rosy picture, let's come to the slightly more grim picture, which is on legal education in India. As in, there are many people on this panel who know about other jurisdictions better than I do, and so I'm just going to limit myself to India. Now, Raj, you mentioned the statistics yourself. We graduate 75,000 lawyers every year in India. Okay, that's an incredible number of graduates to be churning out and becoming a part of the profession. Now, I think I'm going to be very upfront and candid here. I think we do have a quality problem as far as the legal bar is concerned. Okay, and just as an anecdote, even when I was growing up and I decided to go to law school, I was asked the question which many people in my generation and earlier were asked, that did you not get into medicine or engineering, which is why you're doing law? And the fact is that a lot of people, and we think that it has changed with the likes of Jindal and the national law schools, it might have changed for a certain class. But a lot of people do law because at the end of the day, it's a professional degree which has some social standing. But that doesn't necessarily mean that they are good lawyers. So, what is it that legal education gives us? As in, if we were to really try and distill that, I think there is legal education at the end of the day gives us a way of approaching a problem, of thinking about a problem and working a way to a solution. And that I think the Indian legal education system by and large does reasonably well, as just by the fact that we have to take as many courses as we do and have to think about things in such detail. I think it does that. But what it does not do, which I think is a problem, and I hope we can discuss it in the course of this course of the evening and beyond, is that it doesn't provide the skills that I think are necessary for modern lawyering, and specifically are meant to solve problems for people. So we have to understand people. Like, it may be a law itself may be an sort of, in the minds of citizens, an arcane enterprise, but at the end of the day so it's to solve a particular problem. I don't think legal education does that very well.
Okay.
Number two, negotiation. I don't think legal education does that very well either, because that's something that's front and center of what every lawyer has to do. And number three, which is close to what I do, I don't think lawyers are taught by and large to think macro, policy level. Lawyers in our education, we think extremely micro. And a lot of Indian legal education is heavily knowledge oriented rather than skills oriented. And I'm going to leave this question with a thought, which is, I think that if, even not getting into COVID, if Indian legal education really has to solve problems that Indian society faces today, we have to radically rethink the curriculum and the fact that the Bar Council of India sets the curriculum. So I'm going to stop.
All right. Thank you very much, Agya, for setting the stage for this evening's discussion. Let me take this question to Adam. Adam, at least 5 years ago, the American Academy of Arts and Sciences had hosted a panel in 2015 with the title, The Crisis in Legal Education at the Georgetown University Law School. And there are extensive discussions surrounding that. Now, my question is, we are 5 years ahead of that time. Is this crisis assumed a new significance due to the COVID-19, in the sense that some of the fundamental pre-existing challenges associated with legal education has come to the forefront due to some of the reforms that were expected to be taken but were never taken? Adam.
Well, first of all, let me thank you, Mr. Vice Chancellor, for including me in this august panel. I'm, among other things, interested in learning about Indian education. What I know of Indian legal education, I know from Indian law graduates who have come and studied in the US or worked with me, and I have a very high estimation of them. To your question, though, in 2015, US law schools and the US legal profession was still reacting to 2008, 2009 economic financial crisis. Some of the issues that were brought up then we have addressed, and we had until 6 months ago, we were on the track to overcoming. Clearly now, we have to rethink once again our models of legal education. And it's far too early to tell exactly how we're going to do that. What I might do is refer to a couple of the issues that were brought up in 2015, and then talk about a couple of issues that are now facing literally me and my colleagues every day as we get ready for what will be, we hope, beginning of the new school year in September. Going back to 2015, roughly speaking, one important issue there was just the business model of American law schools. And ironically, this touches on another issue, which is the social mission of American law schools, because I would argue that while American law schools can only operate with a consciousness and a direction towards that social mission, in order to keep the lights on, turn on the heat in the winter, they have to take care of that, of their business model. And frankly speaking, over a period of decades, we in the American Academy had gone from a model of small faculties, large classes, simple facilities, to a model not universally, but much more commonly, large faculties, small classes, and over elaborate facilities. We are able to do it in part because students could borrow money very easily, subsidized by the government, to pay our increasing tuition levels. It was a system that for a while worked for everyone. It stopped working around 2008, 2009, and enrollment fell dramatically in American law schools. I should also say that in the US, while we do not have as many law schools as in India, we have a great many, in contrast to systems, say, in Germany or other countries where schools are much more regulated. In any event, we've tried to address that. I'll just speak about Columbia now, because we exist in a particular corner of the ecosystem of US law schools. We've continued to have a large faculty, continue to have whatever facilities we had before, but we have tried to create specific funding mechanisms for students who go through our very expensive program, but want to then go into public service or civil society. One particular approach to that is that if someone graduates from Columbia with a large student debt, but they go to work for a public interest company, we will assist them, along with the US government, in having a suspension of their loan repayments. And in fact, if they continue to work in a public interest job for 10 years, we will assist them and we will forgive their loans entirely. So that hopefully makes a public interest career accessible to students who go through our very good but very expensive program. Just a couple of seconds now, though, on what we're facing is we're having to shift very quickly to online teaching, which undoes some of what we've invested in small classes and personalized teaching and skills training. We're having to deal with the fact that many of our international students, we're very proud to have a lot of students from around the world, are having trouble getting to the United States. And I was joking earlier, depending on the day of the month, it's not clear if the United States government is helping us or working against the law schools. We were prepared to sue the United States government to make schools more accessible to them. So this is part of where we've been and what we're doing now.
Thank you very much, Adam. Thank you for that. And we'll come back to some of these issues you raised. Vikram, let me move to you. Now, of course, Vikram, you are a quintessential poster boy for global law school and legal profession experiences. You went to NYU Law School. NYU Law School pioneered the Hauser Global Law School program. And actually, even when many other US law schools were in a very formative phase of embracing globalization and the legal education, in that sense, NYU played a leadership role. And then, of course, you work for a law firm. And then for the last 2 decades, you are working at the World Bank. So my question to you is that, how do you think the landscape of global legal education has evolved in the last 2 decades? And equally important is that to what extent a multidisciplinary engagement within law schools can help contribute towards the development of the legal profession in different facets, in which opportunities like the ones that you have got, in which it's not a very traditional opportunity that lawyers are expected to do, but you kind of carved out a space in which the role of a lawyer in a large organization such as the World Bank has assumed new significance. How has your own legal education experiences shaped your legal professional accomplishments? Can you unmute yourself, Vikram? We are not able to hear you, Vikram. No.
Can you hear me now?
Yes, we can.
Okay, good. Sorry about that. No, there was some, I got disconnected. So I appreciate your colleagues. The technology sometimes doesn't always work. So thank you again for inviting me, Raj, and it's an honor to be on this panel. I, of course, am a practitioner, so I have may not have deep insights into the theory of legal education and the practice of which you are a pioneer. I think that tribute must be paid to you. As you know, there were many skeptics, including me, but you've proved all of us wrong about the model that you've pioneered. And you've done so with great integrity and, with great skill. So I think I have to give tribute, credit where it is due, which is to you, to really for raising the bar for Indian legal education. I think a lot of credit goes to the National Law School experiment, and rightly so. But I think you've done your part and more. And so I think that that is, of course, a great model. I have only visited Jindal once before, and so I haven't fully immersed myself in how you do things. But I know from speaking to your students, but also from watching what's happening, is that, in a way, your sort of approach is very untraditional. But I still think that the issue you raise is an important one in terms of what can we do better. And I think that I work in a department that has historically had a close alignment with scholarship, in the sense that many of my colleagues are PhDs. Many of them are also just, hardcore practitioners. But the tradition in my department has traditionally been to nurture and encourage scholarship while being very pragmatic and practical as sort of lawyers to an institution, to an international financial institution. I don't think that we bring any particularly different skills from lawyers in any other situation. I think that as we learn as we go along, just as any other lawyers do. And I think that would be my message through law schools, which is to encourage students to learn the core. And then by accretion and experience, you develop competences that you may not have learned in law schools. I think too much is done. I think law schools sometimes flagellate themselves unduly about what they can do better. I think what they can do better is to get law professors to teach better, because I think law teaching has taken a backseat to legal research. And while I think both of them have to continue in parallel streams, the great law teachers of the past I don't see anymore. And that does impact on students, especially if you're charging them a lot of fees. But I do think a strong base in the fundamentals of legal subjects, core legal subjects, whether it's international law, contracts, or civil procedure, or torts, is very essential for a good lawyer to be successful in anything they do. I'm one of those who believes you don't have to learn some hyper-specialized course, because there's time and place for that. And so if you emerge from a law school with cutting-edge legal skills that are sort of grounded in the fundamentals of law, that to me is a great grounding. And from that, you can always embellish through your experience and then through your interaction. One other thing I wanted to say is, I think Adam mentioned the Columbia program. I'm privileged that NYU Law School has instituted the Law and Development Fellowship, which is sort of an internship, but it's more than that. one of my law and development associates is on this call, Doris Matu from Nairobi. And so I've had the privilege of working with graduates from across the world through this program who come and spend 6 or 7 weeks. Many of them are from the developing world. And I think in that sense, I can clearly see that Indian graduates are, as good as any of them. But I do think the one thing that makes a big difference are the opportunities while you're in law school or just after it to do a fellowship of this nature. So that I think is something like Adam suggested, the public interest fellowships where you forgive loans if the students pursue a public interest program widely defined. That I think is something of an innovation that law schools must consider. Thanks again.
Thank you very much, Vikram, and thank you so much for your kind words. But I want to say that I met you for the first time in the year 1995 when you were a student at NLS Bangalore, and Vikram he was one of the tallest in his generation of lawyers, in my generation of lawyers, and even then he was one of those active researchers, and that's an issue which we will come back to a moment. So thank you very much for your comments. Let me move to Jane Shukoski. Jane, one of the things that you have led for a very long time is the need to promote clinical legal education as well as experiential learning in the study of law. My question to you is that how can law schools achieve greater impact in relation to improving the quality of teaching in clinical programs? What can, let's say, faculty recruitment initiatives, faculty development programs can aid in this process? Now, of course, I've always been quite, let's say, amazed in a not so a positive manner to see that a kind of a unique caste system prevails in US law schools when it comes to clinical law professors. And I have seen it mentioned in a very pejorative manner. Of course, Indian law schools have, some of them are pioneered clinical legal education. So my question to you is that, how do you bridge the gap between the role and importance of various aspects of the study of law, along with an equally important attention paid to clinical legal education in the context of law, both legal education and its ultimate impact in legal profession?
I think the idea of the caste system in American law schools is receding as clinical legal educators have been involved both in classroom teaching, traditional classroom teaching, as well as clinics, and have been accorded time and support from law schools for publication, for research and publication. One of the mechanisms for that also feeds some of your other interests in encouraging students to go into academia and do more research is to have fellowships within clinics so that there are extra hands, extra minds to help with supervision of students, so that the faculty member is able to participate in the life of the law school as well as the supervision of students and cases. India is a tough nut here. You know, many of my good friends in India are involved in clinical legal education. And there are so many issues, such as the fact that faculty cannot practice law, full-time faculty cannot practice law. A practical issue with students is that, especially in national law schools and global law schools, many of the students don't speak the local language. So in terms of taking them into fieldwork situations, they're limited in their ability to communicate. I've been out with groups of students where there's one student who speaks the local language who is serving as the interpreter for everybody. So that's better than nothing, but it is limited. And so these are hard problems for India to address. Now, many of those 1,600 institutions, however, are operating in local settings where people do know the local language. So one thing to do would be, in terms of trying to provide service to the whole of society, would be to mobilize those in those law schools with support for clinical legal education, which could be done through academic staff colleges, except I think the academic staff colleges don't see their mandate as being pedagogy, but rather see their mandate as being updates in substantive law. So there are a host of problems. I think people in India and legal education coming together, putting their heads together can address some of these, but it is not a simple solution. One example of a very effective program is in Goa at Salgaonkar Law College. And part of their success is that the students are from there, and the students are going back to their villages, and they're able to communicate, and they know the ground reality. But for the highly competitive law schools in India, where students are traveling from all across the country to come to a place, it's very hard for them to connect with the on the ground situations.
Thank you very much, Jane. Thank you very much for that response. And we will come back to the question of continuing legal education a bit later as well. Dr. Suraj Singh, your journey has been phenomenal. You have come from a very modest beginning in law faculty, Delhi University, and then of course went to Oxford and Harvard, and then returned back to India. So my question to you is that at a time when a new generation of law students entering into law schools, including ours, but also the leading national law schools, as well as even your own alma mater, our own alma mater, Delhi University, their aspirations are to a large extent limited by their intentions to enter into a corporate law firm, work in MNCs and other such organizations, and nothing wrong in it. So my question to you is that how do you motivate and inspire young law students and law graduates to consider being part of the legal profession, to think about being a lawyer in a court of law, to aspire to become a judge? How should the legal profession respond to that challenge? How should the judiciary, including the broader legal profession and higher education institutions and law schools, evolve to provide young legal minds to think in terms of pursuing career paths within the legal profession? In some ways, how do you, inspire the new generation of law students and law graduates to think about being part of the legal profession, particularly to uphold, values of constitutional justice and even, promote advocacy in the context of public interest litigation and many other things that lawyers, at least those who are practicing courts of law across India, tend to do? Dr. Suraj Singh.
Raj, it's always a question of incentive. Human beings are human beings. Unless they have the incentive, that is what they are looking for, they get in life. For example, if I tell my juniors that sitting here in India as a litigator, some of us make more money than our counterparts in New York. So then they would be saying, oh, wait a minute, what's happening here? Like, people think that all the money is there in corporate. That's not true. In fact, depending on at what stage in corporate you are. When law students come to me, they get the training for 6 months, 1 year. For 6 months or 1 year, corporate invite them 3 times of whatever I'm giving, and I'm giving quite competitive stipend to them. The reason is this, that litigation teach you something which is so close to life. When law students come, as Justice Pickering used to say, that law school produces law graduates, not the lawyers. And the journey from law student, law graduate to lawyer itself is difficult but very rewarding journey. When I came back, I started with Attorney General of India, G. Ramaswamy. And in 6 months, for the first time in my life, I lost weight, not in the right way. The reason was that in the beginning, learning all these procedures was so difficult. But at the same time, after Harvard and Oxford education, it did not take me more than 6 months. So all this thing about, oh, law is practical, all that was not really overplayed. So students want to do something. This generation is as much motivated as any other generation to have a meaningful career. Now, meaningful career also means money. money plus making a difference, both. One should not be pitied against either to choose a life of self-imposed poverty or moderate income or making the change. In today's time, you can do that. America is a model. All the billionaires, most of them are, what is their model? Learn, earn, and give away. So that same model in India, we should have, that we first learn, then we earn. Our top lawyers make much more money than their counterparts over there. Only difference is, and one suggestion I will make, this Bar Council does not allow contingency fees, which is not a good idea in a country like India, where many people cannot afford the fees. Of course, there can be some regulation, it can be abused, but if contingency fees is allowed, single one most important factor, and you will see that all this allure of only going to corporate world will change. So we need to, like for example, I do 70% cases of a highly paid fees, but 30% pro bono. Every month, only 30%. If more than 30% people come, I say, sorry, for this month, quota is over, come next month. So 70% so that we are economically viable. 30% so that we can do good things. Now, as Professor Michael Porter of Harvard, again, Business School, say, why NGOs are not viable? Because of simple reason that if there is no profit, there is no scalability. So it is not a wise way that you ask them to make too much sacrifice. Make good profit and share the prosperity. So benevolent billionaire or millionaire should be the goal of all these great lawyers.
Thank you very much, Dr. Suraj Singh. You have, of course, been very candid, and many of your comments we will return back for in the Q&A session as well. We are live on Facebook and YouTube for all the viewers. Please send in your questions shortly. After this particular part of the segment of the session, we'll take some of those questions. Aya, let me move to you. The current pandemic has brought to the surface the need for a human-centered approach in the resolution of legal disputes. I mean, we are barely trying to understand force majeure and its implications for a host of, both commercial and other types of, contracts and arrangements that have happened. Now, my question to you is that what is the importance of integrating design thinking into legal education to create more innovative lawyers of the future? What type of curriculum and activity-based changes and reforms will be required to inculcate design thinking among the students? How can, let's say, institution-specific initiatives such as the Stanford Law School's Legal Design Lab or centralized hackathons such as Australia's Disrupting Law help create this new generation of legal thinkers? Is this the time for both our legal education, but even legal profession to think about fundamental changes and reimagination?
Yeah, I think, Raj, in legal education, as in many other areas, COVID provides an opportunity for us to rethink some fundamental assumptions which we felt were entrenched. And I think legal education is no different. You spoke about design thinking and the law. I think that there is, while certainly I agree that this needs to be part and parcel of every law school curriculum, because at the end of the day, what I feel is intrinsic to any legal education is essentially structure, right? Law is about thinking about structures that work in order to solve certain societal problems. And design thinking is essentially a way of thinking which allows you to picture a particular structure or framework in your mind before getting down to do something, to act on it. But I think this actually raises a larger point, which is a point about methodology. And I think that Indian legal education, again, I stick to Indian legal education because I'm familiar with it. Indian legal education has, at least for the last 50 odd years, as in has become very knowledge centric, right? As we want people to be jack of all trades, know a little bit of intellectual property, know a little bit of banking, and because of the requirements that the Bar Council has set. Now, knowledge in and of itself is fine, but we all know that legal education is not only about knowledge, because at the end of the day, if you ask me a question about what Section 70 of the IT Act is, though I read that act every day, I will not be able to tell you offhand as to what its intricacies are. But if someone were to ask me a legal question, I would perhaps be able to go through how to think about that particular problem. So I think that what COVID has given us an opportunity to do is to rethink about methodologies. And the examples that you pointed out, I'm not familiar with the Australian example, but the legal design lab in Stanford and the idea of a law lab, which has come into prominence lately, as in is essentially a different methodology of teaching and learning the law. And it's much more hands-on, as it's exactly the sort of thing that Jane was saying. Salgaonkar does very well, which is clinical legal education that is actually getting students to see real life legal problems and work with them. This is trying to do it in a simulated setting, sometimes not in a simulated setting as well, but trying to do it at scale, because we are located in cities and not close to our hometowns where we speak the local language. So I think as far as changing methodologies is concerned, this is, as we can look at a legal design lab, but as it strikes me as we in India have found the long way home. Because if we look at traditional Indian education systems, and this, when I talk about that, as in I'm talking about the Gurukul, as in the Gurukul is essentially a methodology, as in now it's become a bit of a slogan, but essentially is it's a methodology of teaching and learning. That is, I think, as some PR person today might call it, they might give it a name like immersive learning or some such thing like that. But essentially, that's what it is. As in, it's a small number of students who are living and learning from their teacher from primarily an oral tradition that is not entirely knowledge based, but is based on a holistic understanding of every aspect of life.
Yeah.
So I think what this opportunity gives us is, one, we need to think, move away from knowledge, and we need to move to methodologies. Number one. Number two, I think the lead has to be taken in law schools like Jindal, which are at the forefront of experimentation, because you're nimble, you're quick. I can see that, and I'm not saying this, I heard it from a third party who was raving about the fact that you offered an online LLM, and it's been subscribed, I think 10 times over, or some number like that was given to me. And I think institutions like yours and other institutions that want to experiment have to move the discussion away from knowledge, which is going to create a person who's a jack or a Jill of all trades, to a person who has the right methodologies for solving, thinking about a problem and solving it. So legal
Right.
design and design thinking is a critical part of that. And I think that will essentially be a return to our own Gurukul tradition.
Thank you very much, Agya, for that. Adam, of course, we know that the globalization of legal education and legal profession has impacted law schools around the world. Law is no longer a domestic study, but a global practice and profession. How should law schools shift gears to nurture lawyers and train them to be, let's say, multi-jurisdictional international lawyers? What is the role of international collaborations between institutions in creating opportunities such as study abroad program, or the kind of programs that you run at Columbia Law School, dual degree programs in advanced global lawyering? How do law schools, particularly in democracies, provide global legal education that will shape and strengthen democratic institutions and democratic governance? Adam.
So just going back to what our colleague Dr. Singh was saying, in part, we the law schools don't have to do it because the market and the world is incentivizing students to go in that direction anyway. The market, in the sense that the great economic actors, large corporations and others, are increasingly, notwithstanding COVID, although we have to see where that takes us, cross-border in their operations and in their agreements and in their disputes. And so they require lawyers, or they favor and incentivize lawyers who have not necessarily a knowledge, going back to Dr. Sengupta's point, of the specific law of each jurisdiction, but a familiarity of either, I'll just call it the legal culture and the overall legal framework in which their clients will be operating across the globe. And so our students come to us at Columbia because they're looking to be able to serve those kinds of clients. And even if you're talking not about corporations, perhaps, but about civil society organizations, which actually are great, very large economic actors as well. If they're providing health services across parts of the world, they similarly have cross-border legal needs. How do we then provide students with what they're looking for there? One way has been over the last generation or two through an expansion of the kinds of programs that I work in, exchanges. And I know Jindal is involved in this, but we will send Columbia students to a school in China or Germany or Africa for a semester and take other students back. Again, the goal is not so much, and perhaps not at all, to make the Columbia students Indian lawyers or French lawyers or Japanese lawyers, but it's to give them some substantive background in a particular area. More than that, it's to let them know what a Japanese lawyer, how they are trained. If someday they may be working for a Japanese lawyer or litigating against a Japanese lawyer or supervising a Japanese lawyer or appearing before the ICJ in front of a Japanese judge, they'll know how that person was trained. So that's what we have been doing. I think we've been doing that. By we, I mean the American Academy and our international colleagues increasingly well. I don't have an answer for this next dilemma though, because COVID right now is shutting down those programs. We're not going to be sending anybody for a semester abroad in September. We normally send about 50. I've just sent in a petition to the New York Court of Appeals, which governs who can take the New York bar exam, because their rule right now is they will not allow someone to take the New York bar exam if they have, to simplify, if they've done online classes from Oxford, from Jindal, from Tokyo University. I'm asking, and I'm trying to be a practitioner a bit myself, make a compelling case that they should make an exception, at least for some of these programs. But we'll see. It's a new world for us.
Thank you very much, Adam. Let me move to Vikram. Vikram, this is a question about the future of legal research. I mean, you went to a leading law school in India and then, of course, the US. During the time when both of us were at law school, research and scholarship with regard to publications within the legal academy in India was still at the periphery and probably at the margins. Although some of the students were taking interest, definitely you were doing that. So my question to you is that, how do you build a culture of research within law schools? And to what extent various international institutions which are engaged in legal research, such as the World Bank's knowledge initiatives, for example, the World Bank Legal Review and the World Bank Studies, or for that matter, the Global Forum on Law, Justice and Development, to what extent these initiatives can inform and impact and influence the development of culture of legal research, particularly in developing countries? How can the law schools from around the world actually engage in such global research initiatives when it comes to promoting a culture of research, both among students and faculty within law schools?
Yeah, you can hear me, Raj?
Yes, yes.
Okay, good. Yeah, no, that's a very good question. I do want to go back though to one thing that on the COVID issue, because
Please.
I think that is something I may be more qualified than discussing, than providing recommendations on legal research as a non-academic. But I'll come to that as well. But the COVID-19 crisis, of course, has had a devastating impact, right? Every one of us now knows someone who's actually been directly impacted. So in a way, this is a truly global cross-cutting, sad, but I guess there is a challenge as well, right, for us as lawyers, because the issues to be considered are so many. The pandemic has severely disrupted contractual and commercial relations around the world. It's brutally impacted justice delivery in many parts of the world, labor and employment concerns. We've seen that in India, health policy dimensions like testing, trade in medical equipment, intellectual property rights now with the anvil of the vaccines and therapeutics. And then, of course, the big issue, which I would say is the big frontier for lawyers, data protection, privacy, contract tracing, Arogya Setu, all of that stuff, right? Now, I think to tackle this sort of multidimensional crisis, I think it's good to be a solid lawyer in the basics, as I said, right? So in a way, this is such a vast crisis that having a sort of a truly multidimensional approach is useful, but having core basic legal thinking is very important to be able to counsel clients, right? Clients come to you saying, well, what do we do about the threat of lawsuits? What do we do about force majeure? How do we ensure that we can protect our employees' privacy of the medical records if we have to submit to state requirements on contact tracing, right? And so in a way, this shows you how nimble you need to be. And so you really need to have a strong, I'm someone who firmly believes it's very important to have a generalist legal education as a base before you specialize. And that's something which puts me at odds with the American system, where you have this cookie cutter approach. You can go to Yale and you can study 5 subjects and that's it, right? Which I think in a way puts lawyers at a disadvantage compared to the solid comprehensive curriculum that Indian law schools have. The problem is, of course, we don't have enough teachers. And then coming to the research issue, I think the research issue has been one that's vexed legal scholars and legal academics in India for a while. Last night, I was reading the book by Professor Alexandrovitz, who brought international law to India, as you know, in the Madras University, where your father was also involved. And that idea that we must have legal research in law schools, I think is an issue that maybe we need to rethink a little bit. Because as I said earlier, I think it's very important for you to have top class teachers, right? But should they be spending 98% of that time on legal research and then 5% on teaching? Now I know I'm simplifying it, but I do think that if you look at economics, right, where you have solid, good economics teachers, but you also have economic think tanks where solid economic research is done. And so my point is that I think that while legal research is important to sort of let's say to create an atmosphere of learning in a law school, what is more important in my view is having solid teachers who can inspire and cater to every student. I think there is this elitism that creeps into Indian law schools where the first bench is taught, and then you just forget about the rest. And I really think that what we really need is a student-centric approach that inspires good research and writing. And I'll come to that maybe in another question about the importance of writing skills. But I also think that research to me is not for research, the purposes of research alone, especially in a law school setting. It's really to inspire students to be better lawyers or whatever else they want to do in life after law school. And in that sense, research shouldn't really be guided by just the goals of research in and of itself, but really the object should really be to produce students who are the very best, who can think and write effectively on a wide range of subjects. Now that's a little bit of a contrarian take. So.
Thank you very much, Vikram. No, I think it was a very important perspective because sometimes we do neglect that element when we look at the kind of policy issues related to legal education that we need to be addressing. Thank you so much. I know that Adam needs to leave quickly, so I'm going to push one more question to Adam very quickly. Adam, as Columbia Law School is transitioning into the new normal of COVID-19, if you can throw some light about the way the next semester and the next academic year is going to be moving forward, not so much about the decisions surrounding it, but the role of online education and how the online legal education imagination is going to be evolved. Is this going to be reimagining the classic an Arizona State University model in which online education has taken to another level? The new globalization of legal education is in the online space for moving beyond MOOCs and Khan Academy and Coursera. Is this all part of a larger policy engagement within Columbia?
Yes. It has been very striking to me because historically, most of the legal academy in the United States, I would say, has been very slow to accept and adapt to new technologies. certainly to online teaching, and the more, if you will, prestigious or self-viewed elite a law school, the less they have been open to this. COVID has changed everything. We, over the course of a week or maybe two over the spring, sent all of our students home and put an entire curriculum online. We're going to be offering our entire curriculum online this fall, while also inviting some students to come back as well. But over the summer, our summer, we have been offering our faculty intensive training on teaching techniques with Zoom. And to some degree, it's a generational question, as you might imagine. The younger faculty, particularly the digital natives, the ones who've grown up with these devices, take to it very quickly. Some of we more senior people have to work harder at it. But what I'm finding is that almost everyone, once you get over that natural human resistance to change, are saying, this can work, I can do this. In some cases, not all, but in some, it's even more advantageous because I can see your face more closely, you can see my face more closely. So it's a matter of learning the technique. The person who is teaching, I'll just mention this before I have to go to a strategy meeting about just this topic. One of the people who's leading our way in this is a clinical professor, Alexandra Carter, who, through her work in teaching mediation and negotiation, I believe she's taught in India as well, is very adept at training skills, and she is training our faculty in contracts, in torts, in constitutional law, on some Zoom training teaching techniques. And she has said she's got those skills because of her work in negotiation and mediation. And I would say it's also because it requires a background to a degree in emotional intelligence, which I think to some degree is innate, but it can be taught. And you have to work harder if you're just communicating through a screen at drawing on emotional intelligence. I think it can be done. I'm going to leave with that. I thank you again, Raj, for inviting me to this. Colleagues, it's so nice to meet all of you. I hope to be with you again, either on Zoom or in person. And to everyone who joined us, thank you very much. Okay.
Thank you, Adam. Thank you so much. Let me move to Jane Shukoski. Jane, one of the things that has happened is that we have begun to recognize more strongly that law school students represent young minds, fresh perspectives, and great legal aptitude, particularly a large number of students who are entering into law in Indian law schools as a preference. So how can we link legal research to social innovation so that the thought leadership that law schools can produce can also combine with, let's say, an effort to build publications for students as well as faculty? In the bigger picture, what can be done to boost research orientation, particularly in countries such as India, where the orientation, as you know very well, is more inclined to focus on teaching? In some ways, is it possible to have institutions which develop both experiential learning through clinical education on the one hand, as well as advancing the cause of serious critical scholarship through legal research?
Well, certainly seminars are an opportunity for guiding student research and guiding students to research topics. And there's a space for connecting students not just to their own thoughts, but to larger movements. So for example, when I was teaching at Baltimore, I had a course called Law and Social Reform, where the students were to choose a movement. It could be left or right, whatever movement they wanted, and to study the approach of a civil society organization that was advancing that movement. So that the student was seeing the work of many minds, they were seeing research, and they were doing their own critique of what they thought the strengths and weaknesses of the approach were. So I think, seminars afford an opportunity, of course, for doing research on any, whatever the seminar topic is, but also there are ways to construct it to connect students to a larger research community. I think interdisciplinary courses are another way to engage students in a broader understanding of research than just researching a legal issue. And there are many opportunities related to clinical work in the community, but also basically broader societal topics. As you know, I'm a real proponent of universities connecting with the Sustainable Development Goals of the United Nations. We have 192 countries that are committed to measure progress on those Sustainable Development Goals. And that is creating lots of research opportunity. We're certainly not used to measuring results in results of legal work, for example, beyond winning and losing. And so that's another opportunity for doing research.
Thank you very much, Jane, for that. Let me move to Dr. Surat Singh. Dr. Surat Singh, we have been watching that the Supreme Court of India is conducting many of its hearings through a virtual interface. Many high courts of India are also doing that. So my question to you is that the legal practice management software, e-courtrooms, technology-led dispute resolution, face recognition software for trials, or even just technology-enabled work from home, all these are going to become new norms in the legal profession. Do you think some of these things will remain for the future, even beyond the COVID-19 world? The efficiency and success of a lawyer, would it increasingly depend upon tech savviness, or alternatively, as we know, this is going to create a new form of digital divide in which a large part of Indian court system as well as dispute resolution mechanisms are simply going to not be possible for it to be integrated into the justice delivery mechanism. What are the critical dichotomies that we are facing in the legal profession as we bravely fight against COVID-19?
There is a large diversity in India. Courts and court district level, it's one kind, high court level, it's one kind, Supreme Court level, it's another kind. So as far as the elite part of the judiciary is concerned, as sophisticated high court levels and Supreme Court levels, technology has been introduced and working very effectively. But at district level, where resources are already very limited, sometimes when the basic infrastructure is not there, and even many lawyers are not conversant with the technology. In some cases, even they can't even afford it. Their clients can't afford it, entire thing on digital shape. So there, it's not all that effective. Then there's a human element also. For example, when you see a witness at a trial court face to face, and in a criminal trial, when you see all the gestures which the judge has the chance, magistrate has the chance to look at firsthand. Now, you can capture that on video conference, but it's not one the same thing. So there will be challenges divided. The division is already there. Like the quality at Delhi High Court or the kind of persons who become lawyers is very different than the kind you find in district level and state level in many of the states. So India, as Adam was saying, is really a continent rather than a country. And those kind of diversities, those kind of challenges are there, and we need to be agile. But introduction of technology also bringing a lot of improvement and a lot of efficiencies. For example, now as a lawyer, if I have a video conference, I know in advance, so I can concentrate my time in a lot of other things because I know the conference would be at a limited hour. Whereas in legal practice, 50 cases are listed, and depending on when your turn will be coming. So there are advantages. The legal profession which will emerge after post-COVID would be in a lot of ways very different than what we have today. So the challenge is that how to take the advantages of the technology so that we become more effective. And at the same time, the basic purpose of access to justice and effective justice is also handled. Another advantage of technology is that we can handle the cases mass way. Let me give an example. In Supreme Court earlier, before this putting group cases together was introduced, every case would be heard. Now, a lot of time will be taken and there was repetition of arguments. So when court management was done, that all the cases raising same questions of law will be tagged together. So instead of doing 10 cases, now 500 cases are disposed of, because 10 cases are not just 10 cases, but 10 cases might be having 30 other cases, 20 other cases, and as a result of that, the same questions of laws are resolved by the court. So technology will both benefit and burden, as well as there are some advantages of one basis. Take for example, we have both studied at Oxford, the tutorial system of Oxford, one-to-one basis or two-to-one when professor one-to-one basis, when you read out your weekly essays and they give the feedback. Now, those kind of things on online can be done, but the intensity, the individual attention may not be of the same quality. But at the same time, you can reach more people.
Thank you very much, Dr. Suraj Singh, for that. Agya, as we know, law is traditionally considered as a discipline of study and a profession that is significantly based on intellectual curiosity and engagement. Interpretation, reinterpretation, and jurisprudential questions are as academic as they are practical. Therefore, how can we engage and even inspire young law students to be serious about doctoral studies, to pursue legal research that could be possibly relevant for policy reforms? I mean, what should we do to strengthen the Indian legal doctorate programs to attract potential candidates with legal aptitude? In fact, we are familiar with the caste system in Indian law schools, in which the most attention ends up being paid to undergraduate students, followed by postgraduates, and then, of course, doctoral students. Is the bane of Indian legal education for the last half a century has been largely because of our neglect of the doctoral programs in Indian law schools?
Yeah, I think largely so. And this is a point where I disagree with what Vikram said earlier. I think that Indian legal education doesn't focus enough on legal research and the ability for professors to do legal research. I think one of the reasons as to why folks don't want to do doctorates in India is because a teaching career in India is almost seen as synonymous with marking hundreds of scripts and basically spending all your time taking project vivas, and is you really don't have the time, nor is there an institutional push towards ensuring high quality research. So I think if we want more and more students to want to do doctoral degrees, I think we have to create role models for them. And who are the role models if it's not the people who are teaching them? And if the people who are, and at the end of the day, I think they need to, that's basically going to be where this intellectual curiosity of wanting to do a PhD is going to come from, number one. Number two is that I think, and we are all complicit in this, as in all of us, the Indians on this panel have all studied abroad, because, and perhaps I'm the youngest of the lot, it was still very much the pinnacle of educational achievement to study abroad, to do, certainly if you were to do a doctorate, as in you'd, anybody if given an opportunity would want to do it abroad. And that's because, Raj, as you rightly pointed out, of this culture of neglect of PhDs for a long period of time in Indian academia. And that's because we don't tend to think of a PhD in law as advancing knowledge in the field, the same way as perhaps we think of a PhD in, say, sciences. And I think that will change, as in, again, with law schools like yours. From my personal experience at Vidhi, as in we really love working with PhDs, because it essentially, they have a way of thinking about things. Again, it's coming back to that method, as they have a depth of research, which I think is critical for all kinds of policy research. So maybe that just gives me an idea that perhaps one of the ways in which we can incentivize this is by walking our own talk and perhaps entering into a collaboration of some kind, so that actually we incentivize people not only to do PhDs, but to demonstrate that the PhD is going to serve real world purposes, that is making an impact in policy. So I think Indian law schools need to think much more about incentivizing legal research and creating role models for their students.
Thank you very much, Agya. Let me move to Vikram. Vikram, you are again coming back to your own personal experience. While you're working for the World Bank, the last 2 decades, you've also been publishing books. You've been working on Indian constitutionalism, working on telecommunication law, and publishing in those areas as well. So my question to you is that, online technology and utilizing technology effectively to enable research has fundamentally reimagined the way research is today. How can online platforms be used to connect researchers across the globe to facilitate collaborative outcomes? Can online research platforms make research and data more efficient, accurate, accessible, global, even integrated? What role can legal researchers play in contributing to the development of such tools such as NYU Law School's electronic publications such as GlobalX? In a way, what are the possible lessons that we in India need to learn from these global experiences?
Yeah, you can still hear me, right?
Yes, yes.
Okay. So, no, I just wanted to take on Orgo's point about legal research. Now, I'm glad I was a little provocative, but I do think that, there was a statistic about 2 years ago saying that 40% of World Bank research publications are not downloaded even once, right? And this is the World Bank's, solid research function, which is peer reviewed and sort of rigorously goes through a rigorous process of quality control. And I think that was a statistic that was, I think took us by a little shock. And it was actually generated by World Bank's own research, that our research is not being consumed, right? So I think that's what I'm getting at, which is research for research's sake. We live in a time where I keep telling my interns and associates, clients are not interested in long memos. I wrote a 15-page memo on UN sanctions 10 years ago. No one's going to read it today. Everyone has today the patience of sort of 2 iPhone screens, right? If you can't convey your legal advice in 2 iPhone screens, then you're sort of ineffective. So with that sort of world today, where people don't have time to read much, and they don't have time to read a 700-page book, which I think, you can look around me, I obviously consume those books, but the rest of the world is not that way. And so to me, legal research, the skill set of legal teachers must move not just in encouraging them to be deeper in their subjects and write, sort of solid tomes and articles, but also to be nimble and focus on things like blogs and engaging with this new technology, right, which you mentioned, which means that they must also really learn how to write better and also teach students on how to write better. I think Indian students, argumentative as we are very good in oral advocacy skills. The big weakness is writing, legal writing. Even the best Indian lawyers fall flat in terms of legal writing. And so legal writing is very important in my view. And if that is legal research, yes, then that's fine. Now, coming to your question on online, when I visited your law school 10 years ago, I was taken and shown the video conferencing center. And someone told me, this is for Professor Vic Kanwal from Michigan to teach students in Jindal. And I have to say, I laughed at it. And I was thinking, this seems so into the future. And, I guess you've had the last laugh because you saw that, that opening before anybody else did, right? Who knew today we would be doing this webinar in a way mainstreaming what you'd already pioneered 10 years ago at Jindal. So again, kudos to you for really thinking outside the box and looking at online teaching before anybody else in India, or certainly in many parts of the world did, right? So I think we need to build on that. The tools you mentioned are useful. Of course, we now have this surfeit of webinars, which, in India. And the question is, when things return to normal, which I hope they will, will all this continue, right? This investment in online technology, and I think it will. We had Justice Chandrachud the other day talk about how virtual courts, while obviously there are lots of questions on the chat, by the way, on WhatsApp on virtual courts and these legal lab issues. I do think that this crisis, one of the silver linings will be greater investment in technology by courts, but also by lawyers and by law schools. And I think that's a good thing. But for that to sustain itself, we really need to retool legal teachers, law professors, to teach students about the importance of technology, right? And that's just not about how you use social media, but also how you blog, how you write effectively in a way that's technologically nimble. So I think that we clearly see that at the World Bank, where technology and data are an important frontier for development. And I think that percolating into the field of legal academia, I think that law schools really need a new vision on how technology will influence legal teaching after this crisis subsides. And I hope you will lead that conversation in India.
Thank you very much, Vikram, for those very useful comments, particularly with regard to how the changing face of legal education will have a space within the online context. But let me move to Jane. Jane, one of the things that we are discussing today is also about how legal education is changing and the new developments, and including the kind of perspectives which Dr. Suraj Singh is talking about, about the role of financial incentives for people to make choices. So my question to you is that, as somebody who has long, pioneered clinical legal education, but also issues relating to social justice embedded in legal education, even in this changing face of legal education, how do we ensure that the fundamental goals of legal education remain the project of social justice, to protect the rule of law and to promote access to justice? How do we continue to be committed to that idea, that vision in which financial incentives alone do not dominate the aspirations of young people to not only choose law, but to be part of the legal profession? In some ways, how do you ensure that we don't end up becoming the title of a famous book by Michael Sandel, What Money Can't Buy, the moral limits of markets, in which everything that we do should not be measured in monetary terms, and there ought to be some things that money can't buy, and there has to be moral limits on markets, and the integrity of the legal profession is indeed limited by our commitment to certain moral norms and ethics that we are which are deeply embedded.
So I recently saw a study, I think it was here in US, of lawyers who were hiring recent graduates, and they were asked what skills, what characteristics and skills were they looking for in new hires. And the top 20 items that they responded, the only one that would fall on our list of skills from law schools was research. The other characteristics were personal characteristics like integrity, dedication to justice, collaboration, teamwork, honesty, those a broad set of skills about being a good person, committed to the profession, committed to justice rather than just legal machinations. And so I think it's important for us to convey to students that, yes, they're learning new skills, but their whole approach to the profession has already begun. And so their honesty and integrity counts, their ability to reject plagiarism as an approach is very important. And the recognition that actually the profession is there to serve the whole of society, even though we fail badly at that. So through the legal education process, to expose students to community settings, to community problems, is usually, for most people, it's very highly motivating because they realize they can be a help, they can provide a service. Then to take that from the local into a larger frame, one of the things that I was raised with here because of the timing of my adulthood was the creation of backup centers. And I think Vinny is doing some of this, but backup centers that provided practice tools for legal aid lawyers, for legal services lawyers, to be more efficient straight out of law school. In the Indian context, it would be providing materials for the legal services authorities, lawyers, and pro bono lawyers. And this is something that students could be doing through centers at law schools, but I think what would be required is for the law schools to actually coordinate so that it's not reinventing the wheel at each law school, but if the various leading law schools would create poverty law practice tools, that would be incredibly helpful to legal services authorities, new lawyers, and I think to motivating people to have a broader understanding of service. I loved Surat Singh's comment about 30% pro bono, 70% feed the family. And those sorts of messages are really important to get out.
Thank you very much, Jane. Dr. Surat Singh, I want to bring, that issue that we discussed briefly about, which is that there are new generation of lawyers who are thinking about legal profession that hitherto they didn't. For example, every year in the inauguration of our own law school's new class, we admit some 900 plus students into our law school in various programs. And last year when I spoke to the students, I asked a question: how many of you are first generation, aspiring lawyers, in the sense that their father and mother, none of them have been lawyers before? And quite remarkably, over 80% of our students raised their hands. Now, of course, if I had asked this question, say 2 decades ago, it would have been a very different answer. So my question to you is that, to what extent we have seen a democratization of the legal profession in which first generation lawyers can actually aspire to become litigators and succeed in the legal profession?
One advantage, Raj, which first generation, whether they are lawyers in India or they are immigrants in America or other countries, this, that first generation is highly motivated because they had to build the empire. Second generation, third generation can benefit from that. So first generation lawyers are more curious. For example, when I came to law school with the vision that how I can use law as an instrument of change, not only at my level, micro level, but society also. It was one of the leading law schools, as you have attended, Delhi University. But what I got was black letter of law, focusing on text without really giving the larger context. And this black letter law approach, though Vikram is right that you need to have technical expertise and most of the time you'll be using that. But there are 2 ways of learning the law. One is learning the law in a black letter way, in a traditional way. And second is learning the law in a grand manner. Grand manner means where law is not defined in a narrow lawyering skills. As famous author Edward Burke said, that law sharpens your mind by narrowing it. Now, sharpening is all right, but can we have a sharp mind and broad-minded also? Say, for example, not only in India, but even in America, despite 6 years of law school, Harvard, first time when I went to Harvard Business School, and they allow courses up to 30% anywhere in Harvard or MIT or Tufts. So I took few courses at Harvard Business School. And first time at business school, I heard of the term big picture. Now imagine graduating from Harvard Law School and not hearing of big picture. Then similarly, other things which, say for example, Harvard Law School or any law school is more adversarial, but how to be collaborative, how to work in a team, that was a new thing. So there are a lot of things new generation has to learn apart from law. And that's why, as other colleagues have pointed out, there are certain skills like interpersonal skills, like teamwork, which are to be taught. So for first generation, knowing that what it takes to succeed, that itself takes time. And but it does not, it is not all that difficult. For example, when I started practice after PhD from Harvard, practical thing, I knew nothing. So my senior would be saying that you are totally useless because I didn't know anything practical. But how long it really took to master me practical things? 6 months. After 6 months, everything was repetitive. So to first generations, I want to say that first year in legal practice may be difficult, but once you have mastered it, it's much more easy and rewards are tremendous.
Thank you very much, Dr. Surat Singh. We are indeed coming to the end of this program, but I want to take some questions that have come. Maybe Agya, let me start with you. There's a question about, for some people, this question is about, does legal education today enable youth to become good lawyers? To what extent people can transcend the corporate legal profession and look at other opportunities, including the kind of opportunities that you are part of or you are leading?
Yeah, so I think the answer to that question is yes and no. Of course, I think the legal education in India depends on where you've got that legal education, of course. But broadly, it would equip you with a base level of knowledge and skills that would allow you to go out into the world. Now, does it equip you to be a lawyer? Sure. But does it equip you to be a good lawyer? I think the jury is still out on that. Now, the other question that you asked is an interesting one, which is about corporate law firms. And I think that let's be very honest, as someone had told me when I was trying to start Vidhi, is that you can do all this if you don't have to survive yourself, and your survival can be taken care of by somebody else. And I think we've got to recognize that a lot of people go to corporate law firms because of the fact that it's seen as a secure salaried job, because we often think of jobs, as when we think of jobs and job security, I think the epitome that everybody has in their minds is a government job. So in law, what is it that is closest to that? And I think people analogize that to being corporate law. But as Dr. Surat Singh rightly said, as far as the litigation career is concerned, though the start might be a little difficult, as in the promises are immense. And there are other options, like you said, as in whether it be academia or it be working in a think tank. I think the key to it all is the fact that our legal education must incentivize and encourage original thinking. I think if we can create original thinkers who are invited to think about various subjects instead of this rote learning of a person who's interested in constitutional law having to do banking, insurance, finance, all that, and vice versa, no biases. I think that's what we need to do. We need to think about the best methodologies to create original thinkers, and then we'll ourselves see that lawyers will flourish in a variety of professions other than corporate law.
Thank you very much, Agya. Vikram, there are a number of questions about an issue that has been a very old issue in India. Abhilasha is asking, but also many others are asking. They're asking about, do you think the restriction on Indian academics from practicing law should be done away with, considering that academia and law practice can and do contribute each other? Now, of course, I will add that this is a very old issue because, the pejorative side of this is that mediocre academics not doing what they're supposed to do in relation to academia are ending up setting chambers and doing practice work and not focusing on teaching. So how do we create a framework, if for building upon this? And the related question is that because in our country we don't have, let's say, academics becoming judges and things like that, how can we take this effort to bring academic engagement into courtroom practice to the next level?
Yeah, it's a good question. I think that sometimes too much is made about the American model where academics are involved. Now, I think that is few and far between. Certainly in constitutional law, you have examples of Lawrence Tribe and others, professors at Harvard who maybe argue one or two cases. But the large majority of cases, even in the US Supreme Court, are not being argued by academics. They are being argued by the equivalent of senior advocates, who are people who are specialized in oral advocacy at the US Supreme Court. Now, it is true that, Justice Elena Kagan came from Harvard Law School, and you have examples like that. And you also have in India the provision to appoint an academic of high standing, at least to the Supreme Court, which has not been done. But I think that, so, I mean, if you'd asked me this question 10 years ago, I would have said this wall should be broken down and academics should be freely allowed to practice. But now that I think about it, and when I look at what I feel is lacking among new law students, which is really core legal skills, my big priority would be really to focus on how we can get law professors to stay in law schools and engage with students, like I said, right? And not to sit in the library and write their own research, which I firmly believe is important. But I think engagement with students, like the Oxford model, I didn't go to Oxford, so I don't know how the tutoring works. Maybe Argo and you can tell us better. But I think that one-on-one attention is important. And then how much time does that leave you for engaging with practice? But when I say that, we shouldn't be thinking of practice in terms only of court, right? You can always have an academic who's involved as an expert, or, let's say as a, either in a case, not necessarily arguing the case, but also providing, legal advice in a non-adversarial setting. So that too is practice. And there may be, there can be, you can have a more of a fluid approach where if it doesn't compromise that time, at the end of the day, you can't police these things. And at the end of, they are responsible primarily to their, now for me, for instance, I cannot take on, I could teach maybe, let's say, a course here and there, but my primary duty is a full-time employee of the World Bank, right? All the other things I do necessarily have to give way to what I'm being paid a salary for. So I think that is, in a way, to me, the guiding principle of how do you encourage people to really do what they are hired to do. Because Indian law also has had, or legal education has had, a long tradition of adjuncts, without that word being used, where practicing lawyers actually were academics, right? There were no full-time legal academics when Indian law colleges started. They were lawyers who came in the afternoon and taught at law colleges. So the divide has not been so pronounced. But to me today, especially since people are paying very valuable fees in law schools, I think it's important, it's responsibility to the students to have full-time academics who focus only on that, but are also encouraged to do other things if it doesn't sort of distract from their main calling.
Thank you very much, Vikram. In fact, it's a very critical issue because this has happened in the past where, without naming universities, I can say that we've had professors neglecting their primary responsibility for teaching and actually ended up doing commercial practice and even set up chambers. And of course, due to a court intervention, that had to be stopped. And besides, violations of the code of conduct or employment regulations within institutions. But this is not to say that there are pro bono possibilities of academics engaged in it. Jane, there's a question which is about to what extent partnership in clinical legal education can maintain the integrity of the social context in which such experiential learning is pursued. Because many a time, whenever clinical legal education is pursued, students are working in communities. You talked about the language barrier, but imagine that is taken to another level in which, and we've had that challenge, we've had clinics both with Yale Law School and with Cornell Law School students coming and spending time along with our students. And how do we overcome that? That's one of the questions that our viewers are asking.
Okay, how do we overcome language barrier?
No, the cultural and other types of barriers in which if we have joint clinical programs with law schools across boundaries, national boundaries.
Right. So one of the strengths of international educational exchange is that students can ask questions that perhaps are not asked in the home culture, because they're from outside and they're seeing things differently and they're trying to understand them. So actually, I think that sort of interaction is extremely fertile, because students can talk about things that they don't usually talk about at home. So caste issues, for example, that may not surface so much in conversation would be, somebody is at my door, could come up and provide a basis for talking through social issues that are not usually addressed. I think one of the benefits, of course, is this pedagogy exchange that you've been reaching for. How do we get new pedagogy into Indian law schools? And that the fact that students are used to different pedagogies and ask different kinds of questions, have different kinds of assignments, is a very rich contribution to those kinds of programs.
Thank you very much, Dr. Suraj Singh. There are some questions which are focusing on dispute resolution and connected that with the delays as well. To what extent it is possible for us to develop an alternative dispute resolution regime that is actually working, which will ultimately possibly help us in reducing pendency in courts?
Raj, before I come to that, I will say a few words about this gap between practicing of law and teaching of law.
Sure, please.
Because I'm in both fields. See, when there is not much interaction between academia and the real practice, it really leaves both sides impoverished. For example, lawyers are so busy in just making money that they do not think, most of them do not think on the larger issues as to how the system can be improved upon. They are pretty much kind of, in that sense, self-serving. So the larger perspective which academia can give, research can give, is missing. On the other hand, academia, barring few outstanding examples who have interaction with the courts, teach a subject which they do not know that practically legal practice, how that is played out. So to that extent, they are deprived of that. It is a mutual interaction which would be beneficial to both. Of course, it can be abused by those unscrupulous elements who neither teach nor do practice. But that's apart. At best level, person like Palkiwala used to teach at Government Law College. How much they can learn. At Delhi University, we started a course, and you are our distinguished member of that course. When top lawyers of Supreme Court and judges came to Delhi Law Faculty, in every week, imagine a person like Fali Nariman teaching, Kapil Sibal teaching, K.K. Venugopal teaching, Arun Jaitley teaching, Soli Sorabji teaching, even for 1 week. So that was a fantastic experience. So we should allow the interaction between the two, and particularly Jindal University has taken a lead of appointing some of the distinguished lawyers as adjunct professor. Now, coming to the dispute resolution, when let me give a concrete example. A person comes to me that, look, I have this dispute with my members. What is the best way? I said, look, if you go to the court, it will take 8 years. But if I can get it resolved, say within 8 weeks, what will you say? He said, that's fantastic. So I said, a friend of mine who has retired as the Chief Justice of India, he does arbitration. Let's appoint him. He's a very fair judge. Within 8 weeks, not 8 years, he decides the whole dispute. The person got 34 crores, 50 acres of land, and then he entered the politics. Today, he's a member of parliament and very successful at that. So the thing is, we have to come out. See, law is all about problem solving. How to solve the problem.
Okay.
People do not come to you, say, tell me about this or that. They want their problem to be solved. So finding the best way. And that's why design thinking is so important.
Thank you very much, Dr. Suraj Singh. We are, of course, getting to the end of this. I have one last question to all of you. Same question. For those students of law who are watching this program, what would you like to tell them as they experience this crisis along with their studies in law schools. What would you like to tell the students who are graduating across law schools in India in the 2020 batch? What is that one advice that you would like to share with them regarding their aspirations to pursue a career in law and justice? I would like to start with Agya.
Well, Raj, I'm going to keep this short. So I think the most important message is that, especially because we live in an age of information. So if there's one thing that I'd like to tell a graduating student, it is the need to think for yourself. I think it's absolutely critical that you think for yourself in terms of what you want to do in life and what you think the right answer to a particular question is. Because in this information age, it's critical that we steer clear of social media, and being as lawyers and to be lawyers, we can make up our own minds as to what is right and what is just. And second, we should always remember, no matter what our socio-economic situation, that the needs of the community and the country are more than our personal needs. So, which is why I think it's critical for every aspiring lawyer graduating in 2020 or after, and all of us, to remember that at the end of the day, the community and the collective is more important than the.
Thank you very much, Agya. Vikram.
Yes, I think that I would say three things. One is to be better writers. I think that with the cacophony on social media, what stands out is good writing. If you see Gautam Bhatia, from nowhere in 10 years or even less, he has emerged, as a great brand in his own right, just by the sheer power of eloquence through writing. If you watch him talk, he, of course, may not come out as a great advocate or brilliant orator, right? But his writing is peerless. So that is one thing. So invest more in writing. That I cannot stress enough. Number two is build a brand, not a self-serving brand, but a brand of reliability. So we have a lot of lawyers, young lawyers on Twitter, right? I follow many of them, but I pay attention to some and I don't pay attention to others, largely based on what I feel is their integrity of what they are sort of putting out there, but also how much they are willing to learn and read, right? I have finished 23 years, but there's so much I don't know. So that humility is also something I would stress. And finally, keep an open mind and learn as much as possible. I think that law students today are uniquely blessed, unlike any other generation before them, in terms of the instant access they have to information, not just in India, but around the world. And so I don't think that any other generation has had that opportunity. So I would make full use of it and, reach for the sky. There are a lot more people, much greater things that we expect from Indian law graduates than what has happened so far. And the future is very bright for them.
Thank you very much, Vikram, for those inspiring words. Jane?
So I would urge students to remember that, graduates to remember that the profession is to serve the whole of society. And that inequality is one of the major issues. We're seeing it all over US, you're seeing it in India. So whatever vantage point the lawyer takes in terms of working with corporations, government institutions, legal services authorities, that keeping in mind inequality and yet the promises of the Constitution is going to be really important to bringing about a better society.
Thank you very much, Jane and Dr. Sarat Singh.
Well, I will talk about a concept called enlightened self-interest. This is very important because people get confused on one side or the other. Self-interest means, as Adam Smith said, that if we take care of ourselves, everything will be taken care of. That's half part of the story. Other part of the story is that if we are just concentrated on ourselves, we will not go very far. So I call it enlightened self-interest. That means you take care of your interest and you also take care of the interest of other stakeholders. You are enlightened enough to take care of yourself and take care of others. So empower yourself. Law is a great empowering field. Empower yourself and empower others. So in one word, discover your own greatness and help others in discovering theirs.
Thank you very much, Dr. Sarat Singh. Thank you, Jane Shukoski, Agya Sengupta, Vikram Raghavan, and Adam. We couldn't have had a better group of outstanding individuals who have shaped the field of law, the legal profession, including litigation, as well as intergovernmental organizations, and of course, other areas of law. I'm really grateful to you for participating in this colloquium. We couldn't have got a better group of people to discuss about the next generation of legal thinkers and lawyers and academics. I deeply appreciate your presence. For all the viewers, thank you very much for your questions. I'm sorry that we couldn't take all the questions, but I do believe that the Global Legal Education Colloquium and the guests that participated who in this have shaped the discourse in a meaningful manner, but also gave us new ideas and new insights into some of the core issues relating to legal education and legal profession. Thank you for your time and thank you for your presence. We will be meeting again on 25th Saturday as a part of our next colloquium on the theme Indian Universities Vice Chancellor's Colloquium, on the theme Shaping the Future of Indian Universities, Institution Building for Nation Building. I will be joined by Professor Dr. Deepak Nair, former Vice Chancellor, University of Delhi, Professor Dr. Pankaj Mittal, former Vice Chancellor, BPS Mahila Vishwavidyalaya, Professor Dr. Arun Grover, former Vice Chancellor, Punjab University, Professor Dr. Dinesh Singh, former Vice Chancellor, University of Delhi, and Professor Dr. Jairup Singh, former Vice Chancellor, Central University of Punjab. These are part of a public interest initiative of OP Jindal Global University, and thank you very much for sharing your time with us. I particularly want to thank this group of panelists for going beyond the call of duty and staying through the session, which is extended beyond the time I had said earlier. Thank you, and my apologies for the delay as well.
Thanks, Raj. Thanks for having us.
Thank you, Vikram. Thank you so much. Thank you, Agya. Thank you.
Thanks.
Bye-bye.